Okay, so today we're here with Jerold R. Gilbert, Esquire, who is a real estate attorney, and explaining where Jerold fits into the process. We're looking at the best way for people to sell their home and looking at the three choices. You can either sell for sale by owner, you can hire the services of a real estate professional, or you can go hybrid or alternative, as I call it, which is where you sell it mainly on your own, but you get some help. And Jerold is the type of person who can offer help. Welcome today, Jerold.
Thank you.
How are you?
Pleasure to be here. Yes, very good.
Good, good. Now, Jerold, you consider yourself a real estate attorney among other things, is that correct?
Yes, I'm a transactional attorney. I handle only transactions, real estate transactions, business law transactions, and estates and estate planning.
Ooh, estate planning, that must be a busy one for you as well.
Yes.
And I'm sure the real estate market's on its way up with the low interest rates and everything, so hopefully that'll be a busy part for you as well.
We're looking forward to that.
Well, why don't you tell us a little bit, I had a question on contracts. I've had people ask me as a mortgage person, will you help me fill out this contract when they're working without an agent? What are some of the big pitfalls that people run into when they're trying to do an offer, or they're trying to, as a seller, review an offer on a property?
One of the biggest pitfalls that I see is they forget about some of the details regarding contingencies. Some of those contingencies being contingency for financing, especially on the buyer's side. Sometimes there are contingencies that are built in that the seller sort of gets bit by, but mostly it's on the buyer's situation on their side. They get into a contract and they're looking to borrow. They have a certain particular time to borrow, or they don't say it, and the loan falls through. They can't borrow, and they're looking at either losing their earnest money or having to do something on the contract to rescue it. But that's mostly a buyer's issue. On the seller's side, some of the biggest pitfalls is they don't describe sometimes with accurate or better specificity what sort of items go with the property, personal property items. The standard contracts that are out today are pretty good about all that, but there does come a time when sometimes you've got to describe this stuff a little more distinctly than what the contract form provides.
You mean I don't get to keep the mother-in-law automatically?
She has to go.
she's a definite go. Okay. Well, let's talk about something that I get a question on: legally binding. Now, what happens in most real estate transactions? Somebody makes an offer, they go back and forth, agree on a price, they go through the schedule, and it closes. But what happens in those rare circumstances where there's a problem? Let's just say the buyer either doesn't do their job getting the financing, or say they get cold feet and they don't want to do it. What recourse does a seller have against a buyer? And then we'll look at the other end of that. On
the situation where you have a contingency for financing built into the contract, if the buyer matches the timelines, the time where they have to give notice to the seller that the loan will not go through, they cannot get a loan for the amount stated in the contract, they should be able to get out of the contract. They should be able to get their earnest money back without any dispute whatsoever. In the event they miss those deadlines, and most people are somewhat negligent on keeping an eye on those deadlines, those timelines, they're very specific, they're very tight, they will lose their earnest money. They will, $1,000, $2,000, $5,000, whatever they put down is called damages.
Damages, okay.
And at that point, they simply, that's the remedy to get out of the contract, is you lose your earnest money.
So there would be no further obligation, like, let's say you were supposed to buy my house and you did not, you owe me, $250,000, that type of thing. It's really limited to the earnest money?
It can be. There's in the uniform contracts, there's a box to be checked whether or not you're going to go for specific performance, which is perform the contract or give me the damages for the loss of my sale. which, you know, you have to get into court, you have to spend the money to get into court to enforce that. It's expensive, and at the same time, you can't turn around and sell the property. The property's taken off the market during that interim. Because otherwise, if you sold the property for the same amount or better, you have no damages.
That's right.
There's nothing left to be arguing about. Or the fast way out, and most people, I would say close to 99% of the transactions are set up in such a way that they limit their damages to the specific, to the earnest money. They take the earnest money and they call the contract void, canceled, and everybody goes their merry way except the buyer, who's $5,000 less happy.
Sure, sure. And that is a pretty typical amount for earnest money, I would say, in Boulder County, $5,000. Sometimes a little less, and obviously with some of the higher priced homes, you're going to find a little more than that.
Quite a bit more, yes.
And because that really has to do with making, getting a sense of good faith that the person really wants to buy the house.
Precisely.
Okay.
What they're measuring the earnest money, well, there's a couple of ways, and I'm not trying to get off track here, but you're looking at, by signing that contract to sell and the buyer agrees to buy, you are effectively taking that property off the market. So they are limited. If they got a better buyer the next day, a better offer, they're somewhat stuck because they've already signed an agreement.
Sure.
So either party going through the transaction until it closes, if it fails, that earnest money is designed to replenish the seller with that delay. What would it cost me to take the property off the market for this period?
So then the seller couldn't say, let's say that the earnest money was $2,500, and the next day they got a $10,000 higher offer than what you offered. They can't give you back your $2,500 and say, we're going to take this offer.
Nope.
They're bound by that contract.
They're bound by it.
Okay.
Contract obligations, that could be, the buyer's damages go into place there. It's not strictly limited by, I don't want to do this anymore, here's your money back. Now the buyer has incurred damages by not getting a property for a profit that he thought he was going to get. If it's worth $200,000, $300,000, let's say $300,000. If the property is worth $300,000 and he puts in an offer of $200,000 that gets accepted, he's got an instant $100,000 gain. Now, if the seller wises up or suddenly discovers, or just for whatever reason, discovers he can sell the property for more and tries to do that, well, he's damaged the buyer by $100,000.
Are they allowed to take backup offers and keep those on hold?
There are contingencies built into the contracts.
Okay.
And this is something that a lawyer or a good realtor knows what to do. They put contingency language into the contract saying, this contract is subject to such and such contract that has been pending, or it's kind of like first in time, first in right. You can't be number 3 and kick out number 1. Once the contract is signed, it's signed and it's a done deal until somehow, some way the parties agree to release it.